Hello everyone, thank you for coming to our presentation. Our topic was the Business and Human Rights Treaty. In 2014, the Human Rights Council adopted resolution establishing the Intergovernmental Working Group on a proposed treaty on business and human rights. After 3 years of consultations, the working group released a number of drafts. In our presentation, we are referring to the third revised draft. Looking into that topic, we found this picture and thought it would give you a first idea what business and human rights is about. You can keep in mind what you first thought when you saw it and rethink about it after our presentation. Let's start with the table of contents. We will give you an introduction, answer the question if this is the right approach, and end with a conclusion. Introduction. The reason we talk about the issue of business and human rights is globalization. Economic globalization has allowed transnational companies to emerge, and such companies are now bigger than ever. Transnational corporations outsource their production to developing countries, where there is less concern for human rights, while having their main offices in Western countries. In such states, the government is simply unwilling or unable to enforce human rights against large transnational corporations. Consequently, transnational companies can abuse human rights without consequence, and they often do so. In order to tackle the issue of business accountability, there have been several initiatives by international organizations. An important instrument that tried to raise business accountability is the UN Guiding Principles on Business and Human Rights. However, the UNGPs are merely guidelines and businesses are not legally bound by it. Therefore, the enforcement of human rights against businesses remain difficult. A more recent effort for business accountability has been made in 2014 with the proposal for a legally binding instrument to regulate in international human rights law the activities of transnational corporations and other business enterprises. The resolution was initiated by the Human Rights Council on behalf of Bolivia, Cuba, Ecuador, South Africa and Venezuela, with the aim of creating a legally binding instrument for transnational businesses to respect human rights. While developing countries voted in favor of the resolution, Western countries quickly struck it down. In order to find more support for the resolution, several changes and drafts have been made to the resolution. However, the latest drafts have seemingly abandoned the original idea of the resolution. Instead of creating a legally binding instrument for transnational companies, it now aims to reinforce extraterritorial obligations of states with regards to human rights protection. As such, the treaty went from corporation-centric to state-centric, which greatly diverges from the original idea. We will now further assess how this treaty approaches business and human rights. So let's look into it. Is the latest draft the right approach? When discussing whether reinforcing legally binding obligations upon states to prevent corporate abuses within and outside the relevant state's territory or jurisdiction, it is important to consider three elements. Firstly, extraterritoriality, which we explain later in following slides. Secondly, the legal strategy of home state regulation. The latter draft was created with the purpose of filling in the governance gaps created by globalization. Thirdly, throughout the history of human rights law, there is a clear shift from transparency to supply chain due diligence. As the quote included in the slide expresses, there are different parties which are concerned with regards to the effectiveness of the transparency requirement as due to market incentives. Business enterprises may just show their compliance through paperwork, but this does not mean that this is true in practice. So what are the arguments that this approach is the right one? What initially strikes us of great importance is the attention paid in determining clear definitions for all the relevant factors influencing the outcomes of the provisions. Furthermore, it is observed that the provisions of the treaty apply to any business activities, including those with a transnational character. Moreover, victim rights and protection become focal points of the legally binding instrument. Which is also very positive is that it focuses around action from the states in order to outline the activity of multinational companies within their territory or jurisdiction. Moreover, it creates tangible consequences when establishing legal liability for multinational companies that abuse human rights in a state's territory. In addition, treaty generally applies a lex loci delicti applicable jurisdiction, which means where the damage occurred for claims brought by victims of abuse, regardless of nationality, allowing for more flexibility and support for right holder to report and prosecute abuse, reducing legal obstacles for the victim to face. Applicable law becomes the law of courtesies, unless the abuse occurred in another state or the natural or legal person having committed the abuse is domiciled in another state. Creating provisions pertaining to conduct in adjudication is a vital step in a legally binding instrument, as it leaves little room for gaps in accountability concerning the actions of multinational companies. Emphasizes the need for international cooperation and consistency in the protection of human rights, recognizing the true complex character of the issue and establishing a wide accountability framework focused on supporting action and corporations.
However, some people believe that the latest draft is not an effective solution to human rights abuses by multinational companies in their operations. If you take a closer look at the article, you'll notice that the language of the article is often too vague, especially pertaining to outlining the means for preventing abuse. Prevention in the legally binding instrument is encouraged, but never explicitly determine exactly how the states are supposed to implement preventative measures in their domestic law. Some states criticize that the treaty applies only on multinational companies and do not regulate activities regarding human rights of the domestic company. Also, the treaty does not step into some complex problem it have, which lead to reservations that a treaty is being an all-encompassing. A related criticism is that a treaty will be of little practical significance given its overly general character. This character risks maintaining a treaty that lacks specificity in its provisions and arguably fails to determine the criteria of exploitation and positively reprimand abuse of human rights. In the proposed draft, it is important to observe that an obligation to protect human rights, provide framework for preventing and mitigating abuse, and to refine the operations of multinational companies in kind is not placed directly on corporations, but rather on the states in the territory of which they operate. Their duties and conduct dependent on the state's conduct and willingness to produce current domestic litigation, unable to eliminate a gap that still exists between multinational companies and mandatory compliance with human rights. When considering the relationship between multinational companies and international treaties, we need to think about state sovereignty as well. State sovereignty is a term that refers to the legal authority and responsibility of an independent state to govern and regulate its political affairs without foreign interference. This means that sovereign states have supreme authority over their territory. The latest draft focuses on regulating states to reinforce legally binding obligations on states to prevent corporate abuses not only within but also outside of their territories. International obligation on states to prevent abuses that are being performed by enterprise both on and outside of their territory can be argued as a violation of the whole state's sovereignty. As we talked in the previous slide, extraterritoriality is an important factor to consider when thinking about if the treaty is the right approach. Extraterritoriality is immunity enjoyed by the international organizations and their official representatives from the jurisdiction of the countries which they represent. It includes foreign states to international organizations as entities, as well as their heads, legations, mission premises, and other assets. It exempts them from local judicial process, police interference, and other forms of constraint while they are on the territory of a foreign sovereign. The draft makes intentionally recognized human rights binding on the state parties, including not only core human rights instruments, ILO conventions, and customary law. This is important over the previous draft, which seemed to refer only to obligation in treaties to which a state is a party. However, it is unclear whether the new formation resolves all issues, particularly with regard to human rights norms applicable to business enterprises, where it is unclear whether this scope refers only to state responsibility or also the direct responsibility of business. The scope of the treaty, for instance, Article 3, it addresses human rights obligations binding on states, and extends for other businesses. The UNGP 12 in its commentary states that businesses must respect internationally recognized human rights, regardless of whether they are binding on the respective states. If the drafters of the proposed treaty and the IGWG truly want to address businesses' human rights obligations in a progressive manner, they must find a way to build on the UNGP's formulation. This provision addresses the delicate issue of legal responsibility in the context of triangular relationship, in which there is a parent or lead company, a subsidiary or business partner, and the affected individuals. The existence and detail of this norm is a step forward in and of itself, but its content is inadequate and confusing. It appears to conflate different modalities of civil liability in a single formulation, and it is unclear in which cases a discharge or rebuttal of the defendant company will be permitted. In conclusion, the resolution was proposed in order to increase accountability for transnational companies. The initial draft tried to achieve the goal by binding transnational corporations, but their draft by reinforcing extraterritorial state obligations. As we have seen both drafts have advantages and disadvantages, we think that we should take the side of initial resolutions. This is because most states don't have enough law and legal system to regulate the activities of multinational companies outside of their own states. Thus, without the existence of Intergovernmental Working Group, which was suggested by initial resolution, we have to rely on the self-regulation and social expectation, which can be unreliable. Thank you very much for listening our presentation. This is the source we used, and this is the questions that need to be addressed in the discussions.